Okay, so I know everybody's going to be joining us. We're going to wait for everybody to get in before we start. So I will say on this webinar today with our illustrious inspectors of election, do you have to have a certain look to be an inspector of election? You both look very similar.
I don't think it's in the code.
Oh, okay. Okay.
Yeah, well, it's not a matter of if, I think, but a matter of when you end up looking like this.
All right.
Like you're served type of thing.
Yeah.
Some things gained and some things lost.
So yeah, we're going to be waiting for everybody to join. We'll start the webinar in a few minutes. We're just waiting for everybody who registered to join us. We're going to have a great discussion today about elections. I for one am glad to be not talking about AB 130 for a change. That's consumed us for the last few months. So we'll shift our focus today to elections, which is always, which I feel is always a hot topic.
Yeah, and you named this webinar Election Pitfalls, and I would argue that we could have named it Election Opportunities.
Oh, okay.
Well, I will let you catch that earlier.
I will elect to have you expand on that more, Kurtis. Let the puns roll in.
Mm-hmm.
So everybody, while I know everybody's joining us, we're waiting for everybody to join. We're just chit-chatting here for a few minutes. Welcome to September.
What do you think, Lori? Another minute or two?
Yeah, I think maybe another minute.
Okay.
Looks like people are still coming in.
Happy Wednesday.
Yeah. Happy Wednesday, hump day. Getting close to fall. That's my favorite season. Love the fall. All right, well, I think why don't we go ahead and get started? I think people might still be joining us, but we do want to get through everything in an hour. So, Miranda?
Hello, everyone, and welcome to our webinar, Elections. My name is Miranda Ward, one of your client relation directors here with Davis-Stirling. We are thrilled to see so many of you today. We have a lot of information to cover, so we're going to get started. Before we begin, this meeting is being recorded. If you require closed captioning, please request it at the bottom of your screen. This video will be available on our YouTube channel after the webinar is processed. And there's a link going into the chat, so you guys can link right up to our YouTube channel right now. We will be taking questions via the Q&A function to be discussed at the end of the program. If you do not get to your questions, please check the newsletter. Reminder, some questions may be answered as the presentation progresses, and too specific of questions will not be addressed. Now on to the presentation. Please welcome moderator and partner at Davis-Stirling, Lori Poole, Kurtis Peterson of the Inspectors of Election, and Jeff Price of HOA Elections.
All right. All right. Thank you, Miranda. Well, let's get started. And I would like to thank both Kurtis and Jeff for joining us today for this webinar. We actually thought of doing this webinar earlier in the year with the effectiveness of the electronic secret balloting, but we thought let's give it, the good part of 2025 to see how electronic voting is going. So thank you for joining us. And I think we're going to start with electronic voting since that is brand new to California this year. And I really want to know, it's now been a little bit over 9 months. What's been your experience with electronic voting, and are you seeing that a lot of HOAs are using it? Kurtis?
Well, our experience with California electronic voting, just like any new law coming forth, has been a little arduous. To be honest, trying to work through all the different civil codes and coalesce those with an already kind of difficult voting process, if you will. And so it's been a little tough, and it's a real learning curve um, for management, for the boards of directors, and even for the legal counsel to kind of work through all of it, get all the pieces in place. And starting with that, the election rules from the get-go. And so we haven't seen as many associations as we originally thought would take onto it, mainly because they just haven't had the time to get their election rules in place, whether they're within an election cycle or whatever the case may be.
Yeah, and Jeff, how about you? What's your experience? What's your company's experience been with electronic voting so far in California?
Yeah, similar to what Kurtis mentioned, I think maybe a couple of things I would just add to that. One of the big questions we get are more people voting, and what we have seen is probably 5 to 10% on average. I mean, I would say the biggest thing impacting votes are, are people upset? Is it very contested? Like that's always gets your biggest drivers. But all things equal, I think we're probably seeing around a 5 to 10% increase. So if your community is used to getting around 20% voting power represented, you might expect 25 or 30, all things equal. But I would say biggest thing we probably come across is, not as many people are doing it like we thought. I think we're seeing a lot of that wait and see. They want to see if, anecdotally, what are they hearing, if there's some case law that comes out, but it has not been adopted very fast by a large number.
Yeah, I think we're seeing that too. I mean, we were certainly prepared for the onslaught of requests to either update or have new election rules that would incorporate the electronic secret ballot. And the onslaught didn't happen as quickly as we thought. It's been a steady stream though. We have had a lot of requests, but it kind of delayed it a little bit. I think a lot of associations probably are waiting to see how beneficial it is. Maybe after this webinar, maybe we'll get more. Who knows? Do you think that the electronic secret ballot process in California is saving HOAs money? Jeff, what's your thought on that?
I hate answering, it depends, but in this case, it probably depends. There are certainly some things that will save. For example, ballot package going by electronic is going to be cheaper than mailing it out. If you are getting more voters than you have seen in the past, you might be less likely to need an adjourned meeting and not have adjourned meeting fees. And then some of the add-ons some associations do, like they'll have postage paid return envelopes or on-site ballot boxes, like those sorts of things you may not need if you want to go electronically. So those are where you could save some money. But it's not just savings. This process does require an additional notice, the notice that says, hey, everybody, we're going to utilize electronic voting and you've been, put into electronic. If you don't want to do that, follow the below steps. And then all those people will reply back. So it's a pretty manual process that we found so far, right? People, sending you a letter or emailing or calling saying, I want to opt out. So that's one thing that costs more. Managing two systems instead of one is harder, more expensive to do. And then anytime you utilize electronic voting, if you send out the links to vote electronically, if you get a bounce back, you then need to send those people a paper ballot, and that's all individually done, which is more expensive than a big batch process. So at a high level, and this might be one of the reasons not as many people are adopting it as we all thought, is we're not finding it to be a big savings for folks.
What about you, Kurtis?
Yeah, I would concur. The savings is going to be in the direct costs is really what it is. But for an inspector like Jeff and myself, it's an administrative nightmare with all the steps that need to be followed with the individual notice of the opt-out or opt-in. And then, of course, following up with the pre-ballot notice, how is that going to be handled electronically? Emails bouncing, phone calls, questions from voters as well as management. It's administratively, it takes us a lot of time. So our service fees are going up for that.
Oh, wow.
Now, hopefully that's, covered by any of those direct expenses that they may be saving, especially by using the opt-out or electronic preferred method. So we're mailing to very few, hopefully, members, and still getting the same participation, I might add.
Are you, Jeff mentioned the increase, I mean, in participation. Are you seeing that as well, Kurtis?
Well, it's tough because I think it varies from association to association. I mean, some associations where I could have swore working with them for years and years here in California, we switched to online voting. That'd be a snap for us to get not only quorum, but get well beyond it with online voting. But that just hasn't been the case in some of these associations and other ones where I'm like, well, they're going to struggle with this. We get to know our associations a little bit, but sure enough, they come through and quorum is met almost immediately. So it's kind of a tough one to answer. But Jeff, I think his numbers are pretty close with about a 5 to 10% increase in participation. For those members that vote online, the fact is we can keep hitting them for those non-voting members with reminder emails to get them to participate. So that's a nice aspect of it.
Yeah, and going back to this concept of, is it saving money? And I think both of you are right. We're kind of, we're probably still too new into the process to really see if it's saving money and having to work out some of those administrative burdens. One thing from me as the lawyer's perspective is I do think that any association that is going through a restatement of their governing documents, the CC&Rs and the bylaws, that's where you might see some money, especially if you're a larger association, because under the law, you have to mail the documents with the ballot, with a mailed ballot. But if you're using electronic secret ballot, you can send the documents by electronically for those members who are voting electronically. So communities that are doing a restatement, I think you really want to look at it. It might save you some money on the printing and the mailing costs for
Absolutely. I can guarantee you that. The association's 500 and under, sending out 100 pages of restated documents. That's a lot of money right there.
Yeah.
And how many people actually read it? I mean, it's paperweight for a paper.
Yeah.
So it's kind of crazy to do that. So yeah, that's going to be a huge savings. I think just overall, over time, as number one, they get the law squared away a little bit better. And people get used to this within their associations and hear good things about it. That they'll make the switch and the savings come down. The administrative costs for our behalf will come down as well.
So you may have already touched on this, but we'll just see if you have anything else to add about. I'm interested in the challenges that you're facing with electronic voting. We have talked about some of them, but Kurtis, are there any others that you're facing with the electronic voting in California?
Well, the biggest challenge for me and for our group is that 90-day voter preference deadline. That's really a killer. We work in other states where they have opt-in or opt-out, and there isn't that deadline. And so that's a real point of contention with the voters, I think, and for us to kind of keep that straight and to have to cut people off at a certain point, saying, you didn't make this decision 90 days before there was even an election. So that's been difficult. And then education between us as the inspector and management and the boards of directors about all these required timelines and following them and the things that have to happen. And, a lot of it's just like, well, I don't understand. Why can't we just go out with this and make this happen? Because we have to follow all these crazy civil codes.
It's hard for us as the lawyers to even keep track of all those timelines as well. So I can only imagine. Jeff, how about you? Are there any other challenges with the electronic voting in California that you're facing?
Yeah, I would say a couple things to add. One is, and probably in particular among some of our older voters, there's some resistance to wanting to vote electronically. Either, I don't want to do it, or I don't trust it. I don't understand it. Something that we're starting to see more and more are people's work laptops, phones, or have pretty strong filters, and they don't want to let anything external go through. So we get a lot of calls like, I didn't get my ballot, like more than when we were doing paper ballots. So, we can try resending it. I think it's real important for management companies to try to get the members to whitelist the email address it's coming from, so it gets through. But we're having to ask someone, well, do you have a different email address we can send it to? So that has been a big issue. And then on the sort of administrating or logistics part of it, like Kurtis had touched on, this original notice that has that 90-day deadline is probably going out about 120 days beforehand. So you get this list from the management company that has, the names, mailing address, property address, email address, and all that. And it's basically live at that point. Every time a member reaches out and says, I want to opt in, or I want to opt out, or I want to change my email address, we're changing that. But at the same time, you have members coming in and out of the community. So you had to adjust that based up really all the way up to the data record for voting. So it's real hard for management to get us a list that can work with that sort of live document we have, which makes that administratively pretty challenging.
Yeah, that's an interesting point, because usually the record date is when the ballots are sent, which is now 60 days after their preferred voting. They've stated what method they want to vote. So yeah, I can see how that would be challenging. And that kind of ties into another question, which is, and Kurtis mentioned, you've got this 90 days before the election for the members to decide the preferred voting method, whether it's electronic or written ballot. What happens if a member requests to change after that deadline? And let's say they indicated one way or the other, and then they want to change, or if the communication was sent out, like with the opt-out, is you will be voting electronically unless you indicate otherwise by the preferred deadline. Are you getting requests from members after that 90 days, and how are you handling it? I'll start with you, Jeff.
Yeah, not a big fan of this. The language looks pretty strict to me. So we've been taking, I guess, the conservative route and said, this is what you were as of that 90-day deadline. So if it was, say, someone by mail, well, we'll mail you out another one. Or if we have a way to, physically give them a replacement. If it's a electronic one, we'll resend it to you, but we need to stick to that 90-day deadline as sort of that line in the sand that we're not supposed to cross. I'd be curious to see if some case law comes out, or if legislature does some cleanup, but we've been taking the conservative route and say we're going to stick with where you were at that 90-day deadline.
Kurtis, where does your company take on that?
Yeah, we've been adhering to it pretty closely as well. It's one of those things. If somebody says, "Well, I didn't sign up for electronic voting," we let them know that, hey, at 90 days, it is what it is. And then we walk them through the online process. So after they get through that, then they seem to be comfortable with it. So it's all part of the learning curve. And unfortunately, that learning curve starts at 90 days out. We really want everybody to participate. We want 100% participation. And we want them to vote in the method in which they feel comfortable. So, if they've opted out, they're getting a paper ballot and they're not coming back for this election. If they neglected to opt out of electronic voting, we're going to work with them to make them feel comfortable in that environment.
Yeah, that's a good point. And I think right now too, that is what the code says. That's their deadline to tell you how they want to vote. And I think it's risky to allow somebody to vote in a manner that is different than what they indicated after the 90 days. But, hopefully, and I don't know why that 90 days was picked. Maybe it was so that you could have more of a permanent document, that you didn't have to worry about continually having to change it up until the date the ballots are sent. I don't know. But it sounds like that's not really happening anyway. That document still is like you said, Jeff, kind of moving about. You mentioned too, Jeff, you talked about members aren't getting maybe the electronic ballots. So one of the other questions, or a question is, Are you finding that? Are you finding that the ballots are being sent to like a spam filter, or is there a common problem? Are the communications to the members letting them know that they may want to check their spam filter after the date the ballots are sent? How are you dealing with that?
So the first notice that goes out, and this might be, we're doing it, and it might be everyone has to do it because of the law, but I'm not 100% certain on it. But we, as a part of it, say, you can check your functionality with the system. If you go to the following website, enter your email address, and hit confirm, and our system will tell you, like, yeah, we were able to get an email to you. I don't know that very many people do that, but that is, a good clean way of making sure it'll work. We do certainly get a lot of people that say, I didn't get the email from you. Now, whether they really did or didn't, we don't know. We don't know if it went to their spam. One of the things that our developer who put our system together has told us is some of the servers and email accounts, they work differently than others. Like Google's better at it than, say, Hotmail. And so we're finding that, you almost will ask, like, well, what kind of system are you on? Well, that's a problem. We're finding you have another email address we can use, or a spouse or someone else on title we can send it to. So there's not really any real way for us to know other than, them telling us.
Wow.
And these emails and with our system, and I'm sure with Jeff's, that these emails are being generated from the server and sent out. So it's kind of a mass emailing, and some email clients are far more sensitive to that than others. And like you were saying, Gmail's pretty good about it. AOL, not so much. Cox.net, oof.
Isn't AOL ending soon? So that might be a problem. I think AOL is ending.
I don't think so. Who
I
knows?
think it might be.
Let's hope it sticks around for a while. It's been with us since the beginning of time. You've got mail.
I think they're stopping. I think I saw an article that they're stopping their email service, but I could be wrong. I don't know.
We'll see. You'll have a lot of upset people because there's a lot of AOL email clients in our lists. But it's generated from the system. So really what we need to do is communicate with management and have them, whatever email you're going to be using to send to the membership, that to make sure that all the members whitelist or add us as a safe sender to make sure that those come through. And if they don't see them, a backup email from management is usually what we work with, and have them say, okay, look for this email from this address. If you don't see it, we've got a couple of opportunities for you to go to this website and request your username and passcode, or you can call them, or you can email them directly, and they'll get you taken care of. So as long as we can verify that voter, and that is the email address that we have on file, then we'll send that directly from our system. And then that usually goes directly through, not our online voting platform, if that makes sense.
Yeah, that does. And on the subject of email, I don't know if this has happened yet, but if a member claims their account or email was hacked, does the association or the inspector of elections have any obligation to verify or remediate that? Kurtis, I'll start with you.
Yeah, you're going to give that one to me. That's good stuff. I really haven't seen that. We've been doing this a long time. Now, email addresses do get hacked, but they don't usually get hacked for necessarily the content coming in, but hacked so they can use their email address to send stuff out on a bot situation. So what we would do is have them probably provide us with an alternate email address that has not been compromised, so we can get them their proper credentials. And if we have to change their login credentials to accommodate for a hack system, then that's certainly easy enough to accommodate.
All right, Jeff, have you had anybody? Have you had this experience yet?
Not yet. I have a feeling it's in my future, but not yet.
Yeah. All right. So one of the other changes by the under the new law that became effective this year was to the statute 5110, specific to the inspector of elections. And it does put some obligations, duties on the inspector of elections, specifically with regard to electronic secret ballots. Things like authenticating the member's identity, authenticating the validity of the ballot to ensure that it's not altered in transit. So what are the things that you've had to do to make sure that you can comply with this provision in the law? Jeff, I'll start with you.
So our the way our system works is, a member will get basically a link. They click the link to go to the unique ballot for them, and then they vote. It's not like they email us back a ballot. Now there's some terms I don't know, and I think Kurtis probably knows vernacular a little better than I do, but like our developer said, it's like a token and a handshake, all these things that happen in the background, so that things, it's just between the member and the site. It's not like when they send it back, I don't know who it came from. I don't know. It's not like they email us back a ballot to know who did it or how it could be altered. But there's a lot of stuff on the software side to make you compliant to that code and protect privacy and security, so people can't hack it, things of that nature.
Yeah, Kurtis,
Right.
what's your experience been?
Yeah, well, maybe we'll just take these one at a time. The method to authenticate the member's identity to the internet-based voting system. Keep in mind that the member's identity is provided to us by management. So getting a clean list and an accurate list is most important. And that's not just for electronic voting, that's for paper voting as well. That we're talking about electronic, which is really important, and everybody's sensitive about their privacy and secrecy and making sure that everything is up to date. But if we don't get a good list from management, it's outdated, or whatever the case may be, then it's garbage in, unfortunately garbage out. We do the best we can. We know what to look for, items like that, to see if there's any flaws or try to catch them. But just like anything, we can't catch everything. And then we'll go to the next one, a method to transmit electronic secret ballot to the internet-based voting system. Is that maybe I skipped one there.
Yeah, well,
I want to talk about transit of the ballot from the voter to the internet-based voting system. So what we were talking about there is we're not emailing ballots back and forth, okay? We're providing login credentials for members to get onto your internet-based voting system to cast their ballot. Jeff, this is the way your system is, correct?
Yes.
And that's a one-to-one handshake with the voter to the database that's storing that data. So there's nothing going really on in transit, because it's a one-to-one correlation with the voter and the database. So, and as I mentioned earlier, this language is really came from another state statute, and they just pulled it into here. So it's kind of difficult to speak about, because it doesn't really relate to how we're performing elections in California.
Okay. Well, and talking about the membership list too, I mean, one of my, horror stories is there was an election. This was, well before electronic balloting, but still with a secret ballot. And somebody was challenging the election, and they went and looked at the envelopes, and it turns out that one of the envelopes was signed by a member who had passed away the year before, and the association had sent out a condolence message in its newsletter. So the association knew this person had passed away. So somebody signed that person's name to the ballot. And that goes back to the membership list. So the membership list should have been updated to indicate that the person was deceased. Now, it could be that there was no name for an executor or a trustee or something, but you can understand how a ballot was sent in that person's name, even though they had passed away. So,
yeah, and keeping in mind the management and the boards, they all do the best they can to keep the information updated. But it's really the responsibility of each individual owner to make sure that their information is updated with the association.
Absolutely. And especially in that situation where somebody else might, under a power of attorney or as a trustee or an executor, be acting on behalf of the estate of the person. It's important to notify the HOA so that your contact information can be included. Okay, so there were a few questions we got before the webinar that were emailed to us that I want to just pose a couple of them to you. Gonna maybe shy a little bit away of electronic voting. These are more general questions, but one that I hear a lot from my clients, because they'll come and tell me that the IOE won't let them do this. So interested in your take. Do you allow board members to know who has voted or maybe who hasn't voted in an election for purposes of getting people to vote? Kurtis, I'll start with you.
Oh, I thought you were going to start with Jeff on this one.
It says Kurtis.
All right. Our stance here at the Inspectors of Election is that we do not necessarily provide a voted or non-voted list. And that's for a multitude of reasons, but mainly to protect the integrity of the system. We don't want there to be a perception of impropriety from any voter, any candidate, or whatever the case may be, that if we provide the list to the board or to management, that they're going out and cherry picking members that have yet to vote that they think are going to cast a ballot in the fashion they deem fit. So we take that off the table. Okay. So we don't necessarily provide that list. Now, that being said, there are certain instances where we will provide that list, and specifically when we're talking about amendment votes that require such a high participation to possibly pass those amendments, and 67%, 75%, then it's kind of all hands on deck. I mean, we need people to go out, and we need them to get, focus their efforts on people that have yet to cast a ballot. Now, we always tell them, please do not, advocate a point of view, just encourage participation. So that's on a case-by-case basis, and it would only be for amendments or maybe an uncontested election where they're only trying to get quorum. So
Yeah,
situations
and
like that.
for
No is the quick answer.
yeah.
But
Yeah,
maybe.
and I mean, for those votes, like you said, the amendment or restatement votes, often if there's that super majority vote requirement, and if they don't get it, but they get a majority of the vote, they will, and they file a petition with the court, which is authorized under the law. One of the things that the association has to show the court is that a reasonably diligent effort was made to get all eligible voters to vote. So without having that list and being able to, yes, you could send blanket emails and e-blasts to everybody, but I find that targeted reminder to the homeowner who hasn't submitted their ballot can be very effective in that situation.
Yeah, and we conduct that as your inspector of election. Instead of having management do it or the board of directors doing it, they would have us go after those non-voted individuals. And we always tell them that it's, depending on how you're going to do it. Now, when you're talking about electronic voting, well, then that's a real nice way to do it. We do that anyway.
Right.
You don't need to worry about who or who hasn't voted. Just keep an eye on those numbers. We'll take care of contacting the non-voting members.
Yeah, Jeff, what's your stance on that?
Yeah, I mean, definitely our preference is to never provide it because there's just a risk that's assigned to doing something like that. If we do it, we are very clear this isn't for board members only. This is, you give it to anyone who asks can get it. If it was a governing document vote, we're much more likely to, because a lot of instances, as you guys were touching on, you have a 0% mathematical chance of it passing if you don't have enough ballots, even if everyone voted yes. So like in those instances, we're more likely to do it. We do offer things, and like Kurtis had mentioned, that help encourage the non-voters. We can send a specific mailer just says, hey, you haven't turned in your ballot. You can send ballots to all the non-voters. In some situations, there's absolutely no chance we would ever, provide it. Like if it's, a contested election and we know like in particular proxies are being used, like we'll almost never, ever provide a list. The only other thing I wanted to add is, we want ballots to be open. So it's a case by case. I think maybe Curtis mentioned if it's uncontested and there's like, we just want to open up our ballot so people can be elected for 2 years instead of like having to conclude or do a holdover, we may help them. That same association the next year, they get 10 people running for 3 spots and they're asking for the list before the original meeting, probably wouldn't.
Yeah. And an easy way to, well, not easy, but the way to solve that issue on the quorum is, amend the bylaws to have a no quorum requirement for annual election of directors. That's what we recommend. All right, I will pose this question to Jeff. How can we be sure that the management company is hiring an inspector of elections who is going to be fair to all board members and not to the board member the management company wants for their best interest?
Call the guys that are on your webinar. No, with this kind of business, track record matters. We're in the integrity business. You've been around for years. We're not going to risk our business for like one particular vote. I mean, there's not a good enough reason for us to ever try to make sure somebody wins. So I would say, word of mouth for IOA who's been around a while is a great place to start.
Yeah, and certainly recommendations from other professionals that work with IOEs like us. We get asked, from time to time if they're IOEs that we would recommend. And, so certainly I agree with that. All right. Let's see. Now, there were some questions that Jeff and Kurtis posed to me as the attorney, because I was shocked to find out that as inspectors of election, when they have to consult with legal counsel, they don't necessarily get the same answer from 2 different attorneys in the industry. That was just shocking to me. Just kidding.
No.
Ask 3 attorneys, you'll get 3 different opinions. But
two attorneys and you'll get 3
attorneys and you'll get 5 different opinions. So,
right.
So I gave them the opportunity to submit some questions to me that they have based on their experience and maybe not having consistent opinions from attorneys in the industry. So I'll pose a couple of those questions. I'll answer them, and then I'll see what your thoughts are. One is, and this is one of my favorites when the law was changed a couple of years ago, is does the inspector of elections, it was a law that allowed for virtual meetings, except for assessment votes. So does the inspector of elections need to be physically present at the meeting where the ballots are being tabulated? So my position was, the statute says that the members have to be able to, you have to have a physical location where members can witness the opening and tabulation of the ballots. And there's a lot of different ways to witness it. It doesn't necessarily have to be witnessed in person. If the IOE can broadcast the tabulation so that the members who are at that physical location can view the tabulation, I think that satisfies the statute. So I do know, though, I had to debate with others in the industry, others in my own firm on that point. But I think to allow for, a lot of inspectors of election are doing it that way. And so allowing the inspector of election to broadcast the tabulation to the physical location certainly opens the possibilities of different inspector of election companies that an association can consider when they're hiring somebody. Any input, Jeff?
Oh, yeah, I was hoping you'd allow for follow-up. Yeah, I agree with your assessment on that. And we've been doing most of our meetings virtually and presenting the opening and the tabulation for members to witness, which is what the law allows. It doesn't say that we need to physically be present. And if we did, we'd be shrinking our clientele pool by a considerable amount with all the travel that we would have to do. And Jeff, I'm sure you would concur with that. That you can't be at 2 places at once, and you don't have the manpower when you got 5 elections in one day to be Santa Barbara, out in the desert, down here in Carlsbad, wherever you need to be. You can't make it.
Anything to add, Jeff?
I mean, yeah, I agree. I know sometimes that creates a thorn for just the process, because you'll have somebody that may use that as a reason to contest the fact that they didn't get the results they wanted. Like they wouldn't bring it up if they did get the results they wanted, but they bring it up because they didn't. So if we can get ahead of that, we think it is a person who's a problem enough and we can accommodate. We're like, let's just go out there and just take that risk off the table. But if you have to defend it, I think it's very defensible based on the two things that you guys just shared.
Yeah. One of the other questions that we do get this a lot, and I will say that this, of course, the statutes are not, they're not black and white. There's a lot of gray in there. One is on the Acclamation statute, which is Civil Code Section 5103, that it requires a regular election, quote, regular election, within the last 3 years. Now, before you can use the acclamation process. So in order to be able to offer election by acclamation, and just quickly, election by acclamation means that when at the close of nominations, there are equal to or less candidates than the number of positions, qualified candidates, than the number of positions. In that case, under 5103, Civil Code 5103, you can bypass sending the ballots, whether electronic or written, and the candidates will be deemed to be elected by acclamation. So that's what acclamation means. The statute requires, in order to be able to use acclamation, that you have to have a regular election within the last 3 years. So the question was, if quorum was not achieved during those prior 3-year elections or prior 3 years, does that count as a regular election or not for purposes of the acclamation? And I will say the law is gray on this. I think it can be interpreted both ways, but I think the intention was to ensure that at least every 3 years we're sending ballots to members. So if you were mailing ballots or sending ballots, now it's mail or electronic, and you just didn't have the vote because you didn't meet quorum, then I still think you're meeting the intention of the statute, which is ballots were presented to the members at least once every 3 years. And I think I think it could be interpreted that you satisfied that requirement for purposes of acclamation. So Jeff, any thoughts on that?
I mean, it's certainly very, very reasonable. I think because it's gray, you can, if another attorney wanted to argue differently, I'd be like, yeah, it seems reasonable. If you're association coming to me asking, I'd probably tell them, just check with counsel because this is a very gray area. And, I always feel a little leery if I'm trying to push them towards a way that puts money in our pocket. Like I want them to do what's right for them. So I'm like, we'd probably say, check with your legal. We're good either way.
And just another question too is, if the governing documents allow for acclamation, but the Civil Code, Section 5103, the requirements in that statute weren't followed, can acclamation still be used? No, the answer is no. That part of the law I do feel is clear. It says, notwithstanding any other provisions of the governing documents, this is the process you have to follow to use acclamation. So if it doesn't really matter what the existing documents say. You've got to follow the statute and make sure you're following all the procedures in the statute to be able to use acclamation. So
yeah, and albeit a very arduous process with a 90-day
the same question about, is it really saving money?
Individual notice, with a reminder. I got to say, it's still an opportunity for associations rather than when this this code first came out, and it was only limited to associations with 6,000 or more units. What? I mean, how many of those are we talking about? So, they pulled that 6,000 unit limit, but made it very, very difficult.
Yeah. So it's kind of the same question of whether it's saving HOAs money. Miranda, I think, we've got about 15 minutes left. I want to see if there are questions from our audience that we want to answer, or
There are
well, you can
plenty
pose the
questions.
question. We'll decide whether we're going to answer them or not.
Exactly. There have been a lot of questions that come through. Everyone who is watching, please remember that we've been trying to keep track of what everyone is answering while you guys have been posing them. So if you don't feel like your question was asked and it was very simple, please remember to go back to the recording and rewatch it. And for you guys, if I missed one, I'm very sorry. Okay, we'll go ahead and start off. For the inspectors, have electronic elections been more successful than traditional ones in restating governing documents?
Yes. And I'm going to talk a little bit outside of California, just because we've been doing them in other states for much longer. And yes, they have been. Now, that being said, as I mentioned earlier, there's still some associations that you just can't get the participation, regardless of what method you use. But overall, it's easier to communicate and it's easier to resend voting notices to non-voting members. And ultimately, it's easier for those members to act upon a ballot electronically than it is via paper.
I don't have a big enough data set. I think we've done one, and big shock, and it's been adjourned. So these things are going to probably take a while. I don't see how it couldn't be for the things that Kurtis just said, but I just don't have a big enough data set to give you a strong answer.
Yeah.
Yeah, I think in California, the data for California specifically, it's going to take a while. I don't know that I even have a client yet that has done a restatement vote electronically yet. So it just hasn't been enough time.
I'll tell you, yes.
Oh, I have?
No, I mean, I'll tell you the answer to the question.
Yeah, just
all
yeah.
the way around. That's full
Yeah.
circle.
Based on other states. Yeah, I would, and again, I think that's one of the biggest benefits of the electronic voting is the money you're going to save on not copying and mailing all the documents for a restatement specifically. So.
Yep, absolutely.
All right. So again, so as questions were coming in, I prioritized some of them, some very general knowledge, but I think that's kind of where people need to be reminded of what they need to be focused on. So do election rules need to be a separate document?
Oh, no, they can be part of the rules and regulations. They can be a separate document. It's not required in the law one way or the other. I will tell you though, as legal counsel, when I'm asked a question that I need to look at the election rules, I'll look in our file, and if I don't see a document called election rules, I'll start to panic a little bit. And then I remember to go into the rules and regulations and see if they're in there. And actually, when I find them, if they're part of the regular rules and regulations, I'll retitle, just for our internal purposes, I'll retitle it rules and regulations, and then I'll put in parentheses election rules page whatever. So that, because we do look for the election rules quite frequently. So but no, it does not have to be a separate document.
So so let me clarify this one with you, Lori. Does it need to be a separate document from the bylaws?
It is a separate document from the bylaws. It is a rules and regulation document where the election rules are consistent with laws that may have come out after the bylaws were written. The election rules are going to take precedence in the event of a direct conflict, but there are still things in the bylaws that take precedent over the election rules in the event of a direct conflict. Things like cumulative voting. If you cannot put in your election rules that there is no cumulative voting if the bylaws still allow or require cumulative voting. So you have to, it's a little bit of you certainly have to be knowledgeable to know when you're looking at election rules or bylaws, which provisions supersede the other based on what the law says.
Mm-hmm. Wasn't
but
that
they are a separate set of documents, and as I read 5105, it is requiring it to be, a separate document. I suppose if you have the bylaws that have all the provisions of the election rules, there could be an argument that maybe you don't need a separate document, but in that case, why not just have election rules that mirror the bylaws and avoid a risk?
Yeah, well, isn't it a lot easier to go ahead and get election rules adopted than it is to get the bylaws amended? That's kind of a no-brainer to have it as a standalone so it can be worked on from year to year with the ever-changing legal environment of California.
Yes.
Gotta love it. All right. So our HOA does not have updated election rules, and the IOE said that they are not needed. Is this true?
Jeff, Kurtis, who wants to take that one?
Whoa. Well, I guess we would never say they're not needed. We have moved forward with elections where election rules were not in place as of yet. And then we rely heavily on the other governing documents, whether that's the CC&Rs, the bylaws, and then, of course, the civil code.
Jeff, your thoughts?
But they should be there. I mean, we're looking for them, and we won't touch electronic voting until they have those election rules in place. That's for sure.
Yeah, the first thing we would say, get a hold of your attorney, get these going. What you don't want to do is, because an association doesn't have it, then they can't have their annual meeting in 2025, and then everything gets screwed up. So in those situations, we'll be like, listen, it'd be better off, but if you don't have any other choice, we would, in a lot of the cases, move forward following, minimum the codes and their governing documents that they do have. But if they're like, well, we want to pick and choose, and the election rules, if you have them, say you can't have somebody that has been a member less than a year, like if it's not in your election rules, we can't use it. We get your election rules.
Yeah. Yeah, I think it really is going to depend on the situation too. I mean, I tend to be more conservative here and say, I mean, the law is pretty clear. You have to have election rules, and it has to have these provisions, and that was changed in 2020. So the election rules all had to be updated after 2020, and so or in 2020. So I think it's risks a challenge. Now, I will say, if all the processes were followed in the civil code, all the secret ballot processes were followed, then you've got the argument. It's how was a voting member prejudiced by the fact that there weren't election rules? So you could certainly make that argument, but it risks a challenge. And I have advised clients to postpone their annual election to get valid election rules in place so they have them before the election.
Yeah, and we've certainly done that too, where somebody brought that to concern as we were starting out the process. Well, you don't have election rules in place. Okay, let's put the skids on, get some election rules in place, and we'll see you in 150 days or so. However you want to work it, but it's safer for us as inspectors to certainly work within the bounds of the 5105 set of election rules. Absolutely. It's nicer for us. We don't have to do the guesswork. It's all right there.
You're safe than sorry. And I apologize if you guys already got this one, but what's the verification process for eligibility of owners?
Oh,
So determining that an owner is an owner, I'm guessing.
Yes.
That's a good question, actually, Kurtis. Jeff, I'm interested. I mean, I'm assuming you rely on the membership list that's provided to you by the management company
yes.
or the board.
Yes. That's all we've got, really. We're not doing title searches for a 2,000 unit association. If one comes up into question, and this is usually more in a nomination scenario where we get a candidate that's submitted that may be a spouse of somebody who is on title, but they're not on title. And then we have to chase them down and say, hey, you gotta, show that you're on title, or a trustee of a trust, whatever the case may be. So if that answers your question, ultimately, our membership lists should be verified by management, provided to us prior to the get-go of any election process and during, as new ownerships come into play.
Yeah, Jeff, your thoughts?
Yeah, the candidacy thing is a big one that Kurtis just mentioned. And then sometimes around that data record, like we might get the membership list 2 weeks before ballots get mailed out, and the data record is the day they go. So somebody might say, I never got my ballot. Well, we need to show that you were on, ownership as that data record. We can go straight to management sometimes, or the member can send us a copy of a document that shows it. But we're almost all situations relying on the membership list from management.
Yeah, which is, we talked about this earlier. It is so important that that membership list is accurate. If there may be spouses, but only one's on title, only the one who's on title, that name should be on the membership list. So, and I agree. I mean, if there's an expectation that the inspectors of election are going to pull title for every single voter, every member, then you're going to just see the cost of the inspector of election fees increase.
We'd make lawyer money.
So the overall message is, members, make sure to keep all your stuff up to date to help everyone.
Please help yourself. Yeah.
Yes.
Wonderful. All right. What do we say to owners, husbands, and wives who insist The Davis-Stirling Act allows them 2 votes. Lori, this is to you.
Well, I look at the documents. It's usually the documents are pretty clear that each separate interest, whether it's a unit in a condominium or a lot in a planned development, gets 1 vote. And usually there's provisions that talk about co-members. And basically the position of the HOA is we're not going to get involved in your dispute. You co-owners figure out who's voting and how you're going to vote. Don't involve us in your argument. It doesn't really say that in the documents, but you can read between the lines.
Yeah, and in most of the election packages that we put out, we have something to that regard, that there's only 1 ballot per unit or per lot, and owners of that unit or lot need to agree collectively on how to cast their votes or vote on the single ballot.
And there's some, it's rare. That is how it's set up in most associations, is the separate interest gets 1 vote. There are some instances, commercial associations are more common with this, where there is some kind of fractional voting based on ownership or square footage or something. That's more rare. The more common is the 1 vote per separate interest, but that's going to be set forth in the CCNRs and/or bylaws.
Yeah, and that's not just in California. I mean, that's across the country. That's what we see. Unless it's, like you said, percentage based on a condominium unit where it all adds up to 100,
Right.
but the unit still only gets 1 ballot, and the
Yeah.
owners of that unit get to vote it as a
Yeah.
group.
Yeah.
I've had this argument before where it's like, well, we both own the lot or the unit, so we should each get 1 ballot. And I said, well, what if, the person next door is owned by an LLC and they've got 15 owners in that LLC? Do they get a voting power of 15 then? Well, you just get 2, and your next door neighbor, who's a sole owner, only gets 1. So that's just, it is what it is.
Yeah.
All right. So can an owner change from a mailed ballot to electronic in the middle of an election?
90-day deadline.
And that, yeah, we talked about that a little bit earlier. And Jeff and I are in concurrence on this, that we're kind of adhering to the 90-day deadline at this point and hoping that they change that, in the future, to just allow for people to change their preference at any point throughout the process up until a given point, maybe 5 days or 7 days or whatever, not even, whenever. But right now we're adhering to that 90-day deadline. I think to avoid any potential contest of somebody saying, well, they were supposed to vote via paper ballot, but you let them do it online, or vice versa.
Or
We don't need that contest. I know, Jeff, you don't need that contest. I don't want that. We're going to stick to it, and like we talked about earlier, that whatever method they have, we're going to make every effort we possibly can to make sure that they can vote in that fashion, even though it may not be their preferred method.
Or they could say you allowed so-and-so to change the way they
Yep,
are
exactly.
voting and you didn't let me.
Hmm.
It could be
Again,
silly.
this is all to protect the HOAs.
We could be in a giant banquet hall for 5,000 member community, and somebody walks up and is like, I want a ballot, and like, well, pull your phone out because I got to email you the link, and you're standing right in front of me. It's just what you got to do.
All right. Can the opt-in, opt-out option be included in the annual Civil Code 4041 notice to members? Lori, this is to you.
Yeah, I think that it's probably not a bad idea to do that. However, depending on when you do that in relation to your annual election, it could be a problem. Like if your annual election is not going to be for, another 11 months after you send out the 4041, then you got to question the validity of the information. So but in theory, I think it certainly could be added and isn't a bad idea to be added in there. Whether there's going to be another opportunity and another notice sent closer to the election, of, hey, we're going to do opt-in or opt-out, and here's the deadline to set forth your preferred voting method, because you still have that 90-day deadline, regardless of what you put in the 4041 statement. So, I don't think it necessarily hurts, but I'm not, but it depending on when the timing of it might not be that useful.
Yeah, and either way, especially with the opt-out method, we still got to send out that 120-day notice to give people the opportunity to change their preferred method. But I would say there's absolutely no harm in that, and probably encourage it to try to keep the best records for each election going forward. So when they provide us the list, management provides us the list as the inspectors of election, then we have a strong list to work from. Okay, well, this person has already chosen written paper ballot, but we're going to give them the option to make that switch up until 90 days prior to the meeting date or the election date. Yeah.
And a reminder too, to any associations that have changed their election rules, or even if you haven't, actually, honestly, any associations now, as a reminder, if you think you're going to use electronic voting in the future, if you're going to amend the election rules to allow for electronic voting, your annual policy statement has to include information about how members can opt in or opt out. And last year we kind of got a pass for all those associations where the fiscal year starts in January. You kind of got a pass last year because the statute wasn't in place. But this year, you need to have that language in your annual policy statement. And the way we write it is we write it for maximum flexibility. It's if the association adopts election rules to allow for electronic secret ballot, here are the processes for opt-in and opt-out. So we cover all the bases, even if your association hasn't adopted election rules yet, that in the future, if they do, and the board or the election rules or whatever specify opt-in versus opt-out, you've already got that language in the annual policy statement. So remember, get those in this year. Little PSA. So
we always love those.
We're
at 102. Do you want to keep going, Lori, or
why don't we take a couple more questions if that's okay with Kurtis and Jeff?
Two.
Okay.
Two.
Or three, or five.
The IOE has spoken.
Yeah.
Right, now I had to pick some really good ones. Okay. In the event of a tie and the candidates choose to have a runoff, does the same guidance cover the runoff?
Yeah, we fall in the same. Well, I mean, it's a 30-day balloting period is really what it amounts to in a secret ballot. So we follow the same procedures as we would for normal balloting, but we don't do pre-ballot noticing. It's a runoff. It's between those tying candidates, whether it's 2 or 3 or more. You never know. But yeah, we follow the same civil code balloting process. Absolutely. And then schedule a meeting for the members to witness the opening and the tabulation of that runoff election.
Do you ever if it was 2, do you ever let them just flip a coin and decide between themselves who's going to take the spot?
Well, we certainly make that an opportunity before ever going to a runoff, which is going to cost the association more money. And even before a flip of the coin, would one of you like to concede to the other? And sometimes it's a battle between terms, a longer term. Would one of you like to accept the shorter term? So that's always the preferred method. 1, to concede. 2, let a game of chance, a flip of the coin, draw some straws, whatever the case may be. And last, and certainly the least best option is going to be a runoff election.
We handle it the exact same way.
All right, one more. The board did not have any election. They are continuing to stay in office. What is the penalty for that, and what can members do?
Contact legal counsel. That is a very specific question, and it's going to have very specific facts and circumstances that we can't possibly answer. So
I'm not touching that.
Yeah. Contact legal counsel if you're on the board. Certainly contact legal counsel. If you're not only on the board, contact legal counsel also and provide more specific information. How about one more question? Because that one we really couldn't answer.
Yeah.
Okay, I'm trying to find a good one. have the inspector set up a method? Okay, have the inspectors set up a method in their system for sending community association managers copies of the email notices?
Ooh. You mean for the ballot, when the ballots are, when the email is
I'm
sent about?
assuming that's all that the question asked.
Okay, so assuming the question is when the emails on electronic voting go to the members saying, here's your link, does the manager get a copy of those emails? Or
If I understand the question correctly, that, yeah, we always copy the manager on everything that we send out to the membership. Now, keeping in mind, it's got a unique set of credentials, or in Jeff's case, a link to log into a specific voter account. So that manager should not be forwarding that email to anybody else, because that would be set up for, we set up a dummy voting account so we can track everything that goes in and out via that email. Jeff, I would assume you have a similar process for that.
We let them see everything before anything kind of goes to print, or now print or email. I get real nervous to kind of both use about forwarding. I think what we did is we'll send them snapshots. This is what it looks like. I just don't want anybody getting a link for anybody that it doesn't belong to. If somebody wanted like a dummy to see what it looks like, we've done a lot of, as we've been doing sort of intro or road shows on how election works, we'll, sit up in front of a community at a meeting the members are at and show them this is what it looks like, it goes to you. But we hadn't done it yet where we've say added the manager as a member and then they get a ballot link and then, pull them back out. We haven't done that, but we're fine showing them everything, whether it's like a dummy sit up or a snapshot of what it looks like.
So managers, don't be afraid to reach out to your inspector of elections with any questions, or if you want to see those, I would say, right?
Yeah.
Yeah. Well, for our system anyway, the manager's copied on everything that goes out to the membership.
All right. Well, I think we have we're beyond the hour, so I want to again thank both Jeff and Kurtis for joining me today for this webinar. I think it was really insightful, especially into our new world of electronic voting. Jeff, how can people get in touch with you?
Email or phone. Our email is info@hoaelections.com, and I'd say if you want to talk to us, email us, and we can set up a time to call, because that way you don't have to write down our phone number. But those are the two best ways.
All right. And Kurtis, how can people get in touch with you?
Well, just go to our website, theinspectorsofelection.com. You can give us a call, 888-211-5332.
All right. Thank you so much. Thank you, everybody, for joining us today.
Thank you.
Have a wonderful day.